honorable court in the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, sir. Mr. Bekovich.
Assistant Public Defendant Bukovich, likewise, Your Honor, public defender does not believe conflict does exist within his honorable court and the office of the public defender. However, one does advise we do waive it.
All right. Court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the cases of the people versus Anthony Holston.
Morning, Your Honor. Raymond Cook for the
Conrad Siller on behalf of Pittsfield Township.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mrs. Holston in all matters.
And Mr. Holston, can you state your name, please, sir?
Anthony Holston.
Thank you. What are we doing?
There are free forms, Your Honor.
Are there? Got it. I have.
Do one for all the township cases as well as one for the state cases.
I have 2 files marked for please. Is that right?
Yes, that's correct.
Okay. In the case ending in 0070, the court's understanding that he's going to plead to the charge of trespass, 30-day offense. On his successful plea to that charge, don't you guys set this up? Okay.
The other four township cases would be dismissed, Your Honor.
Right. I would have the case ending in 0020, 0021, 0069, and 0067 would be dismissed.
That's correct.
Yes, Your Honor.
So those 4 would be dismissals upon his plea to that charge. The other matter, case ending in 0800, going to plead to the charge of retail fraud, 2nd degree, the 1-year offense. Upon his successful plea to that charge, counts 2 and 3 in this case, as well as the case ending in 798 would be dismissed. Defendant in that case is agreeing to pay restitution on all counts, including dismissed counts, and the prosecutor will recommend fines and cost and restitution. Now that I've sorted all those files out, that's the court's full understanding of the agreement.
As it relates to the state's cases, that's correct, Your Honor.
As for the township cases, that's correct.
That's all cases. That's correct, Your Honor.
All right, very good. All right. Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please.
Anthony Holston.
All right, starting in the case ending in the township case. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges, but in that case, you're going to be pleading to the charge of trespassing. That's a misdemeanor punishable by up to 30 days incarceration, a $100 fine plus court costs. Do you understand that, sir?
Yes.
In the other case, you're going to plead to the charge of retail fraud, 2nd degree. That is also a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
To the charge of trespassing, how do you plead?
Guilty.
To the charge of retail fraud, 2nd degree, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial in either of those matters.
Yes.
You had executed on your behalf after going through it an advice of rights form. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand you're giving up all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
yes,
All right. You're not on probation and you're not on parole. Is that correct, sir?
no, sir.
Oh, well, we did that wrong. You're not on either one of those. That is correct.
Right, I'm in prison right now, sir.
You're incarcerated. That's what, yeah, right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no, they haven't.
You're doing this voluntarily and of your own free will,
Yes,
and also because you believe that you're guilty of these offenses?
yes,
On the date of, starting with the trespassing case, December 27, 2024, location of 3145 Ann Arbor Saline Road, Pittsfield Township, Washington County, State of Michigan. Were you on the property of Meyer?
yes,
Had you previously been told that you were not welcome on that property and that you could not enter that property?
I don't really remember, Your Honor, but if they say I did, I'm sure they did.
Oh, well, we're gonna have a. So you don't recall being told not to go on that property?
I mean, from where? From the hospital or what?
No, this was at the Meyer on Ann Arbor Saline Road. Well,
Okay.
when was the
Right.
date? You know what? Let me do it this way, sir. Because I think one of these cases leads, no, it doesn't. So at the 3145, you don't recall whether or not they told you not to go onto the property. And if you don't recall, that's okay, sir.
I mean, yeah, I vaguely remember. I mean, yeah,
Okay, let's try this. Let me go to the other case, okay?
all
And
right.
then can you, if it's acceptable, can somebody send a police report on that one on the trespass? And I'll try to get it done, but get it done as a no contest.
I will try to send both.
Try to send it over. Okay.
Nobody over right now, Your Honor.
So let's do this, sir. On December 22nd, 2024, location of 3825 Carpenter Road in Pittsfield Township, that also being a Meyer. Did you go into the store on that occasion, sir?
Yes,
All right. Did you try to take items from the store without paying for them?
yes,
All right. And the store was open to the public at the time that you went there?
yes,
You didn't have anybody's permission to take any of that property, did you?
no,
And the property that you took was property that Meyer had offered for sale?
yes,
And had you previously been convicted of retail fraud in the second degree back in the 62A district court? I don't have a date.
I believe January 26th of 2018 or January 9th, 2018, both were.
2018 or 19?
Both,
Yes.
both 20, it's either January 26th or January 29th of that year.
Okay. Do you recall being convicted previously of retail fraud second degree, sir?
yes,
All right. So I have that one.
And I'm sending the police report right now, Your Honor.
All right.
Sorry about that.
Sir, we're trying to so that we can resolve the trespassing case. We're having the police report sent over. My understanding is that you would be changing your plea to a no contest plea.
I mean, yeah, I mean, if that's acceptable, I mean, I can't say to you that that somebody told me on that particular time because what's going on with that is that I'm not from your county. So I got stranded there for 2 weeks, and that's what all this stuff is. So I don't know if that was the first time that I went there. You know what I mean? Like, I don't know if that was the first time that I went there and committed that retail fraud that somebody told me not to be there. I don't know what date that was. So I can't really honestly say to you that they told me what that was, because I'll be honest with you. I went in there a few times.
Okay, I got you. And that actually, Mr. Holson, that all makes sense. I get it. So if you change your plea to a no contest plea, that would mean that you're not further wanting or desirous to contest this charge of trespassing. You understand that, sir?
Yeah, I'm not contesting it. Yeah, I'm sure. I'm sure if they said that I did that they told me, I don't think that they're particularly lying. I just don't recall them telling me that I wasn't supposed to be at that particular time.
Sir, I understand all of that. I'm just trying to get this done. So if you're going to plead no contest to that charge, you understand that all the rights that I indicated to you before would apply to a no contest plea as well as a guilty plea.
Yes, I do.
All right. And you understand that upon pleading no contest, that the court would treat you the same for purposes of sentencing as though you had pled guilty. You understand that, sir?
Of course.
All right. And counsel, the court has been provided Pittsfield Township Department of Public Safety report for their case 24-21532. Any objection to the court reviewing that report?
No,
Your Honor.
All right. And Mr. Holson, just as a formality, to the charge of trespassing, how are you pleading now?
No contest.
Thank you, sir. This might not work. Got it. And the court is accepting it based upon a review of that report. The court does find that there's a sufficient factual basis. I would indicate that based upon the court's review of the police report that the defendant doesn't remember. There's also an indication that's the time of this offense that he was highly intoxicated to the point that he was taken to the hospital at that time. So, sir, I do have to, and so the court does find there's a sufficient factual basis. Sir, I do have to advise you, if we do, between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct that's defined in the Michigan court rules, you will not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir, I do.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Statement.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right. In the case ending in 800, which is the state case, the court will accept the defendant's plea to count 1. Counts 2 and 3 in that file are dismissed, as well as the case ending in 798 is dismissed. In the other matter, court having found a sufficient factual basis, the court will accept the defendant's no contest plea to the charge of trespassing, and cases ending in 0020, 0021, 0069, 0067 are dismissed. Are there going to be issues of restitution on these?
Very
Not-
minimal.
There's no restitution in the township cases.
On the state case, it's going to be a very minimal amount. I believe that half a bottle of Fireball was drank by the defendant as part of that offense, which obviously they weren't able to recover, and I don't know the value of that. So it's a very
A half a bottle of Fireball?
I was gonna ask,
How much does that cost, Bukovich?
I guess I'm here.
I mean, okay, that was wrong. I just thought I'd ask you. Maybe you knew.
I don't drink Fireball.
Yeah, okay, fine.
courts inclined to leave restitution open for 30 days.
Yeah, why don't we do that?
Yeah.
All right.
I was in custody immediate sentencing. My client's been in custody since July 2025 with an estimated release date of November 2027. And I know Mr. Still has indicated he has no objections to immediate sentencing in the city.
That's correct.
All
In the
right.
township matters, I have no objection to immediate sentencing.
Mr. Olson, anything you want to say before I impose sentence?
No, sir. I actually went to rehab after these incidences, and I had a warrant come up, and actually that's why I'm here right now. So I'm actually trying to get. I've completed both my classes that were required for my parole stipulations. I completed ASAT here in the prison. I'm just trying to get. I'm trying to get my life back in order, and alcohol has been my number one legal problem, source of my legal problems. So I'm really trying to get that squared away and understand why that it is that I keep going back and doing the things that I don't really want to do, and doing these, idiotic things like going in and stealing bottles of Fireball, that I don't do sober. So I just want to say that I'm sorry. You know what I mean? There's really no more I can say. I got a problem and I need to deal with it, and I need to seek help for it. So that's what I'm doing right now.
All right. You'll get there. On the township case, I'll impose the state minimums of $125, 30 days incarceration credit, 30 days served on that case. On the state case, I will sentence the defendant to fines and cost of $125, which would be the state minimums, and 365 days credit, 365 days served. All right. Then you're all set, sir.
Okay, thank you.
Okay. Thank you. This case. All right. Court does call the case, People versus Carla Bristow.
Braden Cook for the people.
Alexander Hermanowski with and on behalf Carla Bristow, who's appearing by Zoom. Carla, please state your name for the record.
Carla Bristow.
Thank you. I have before me a plea that indicates that the defendant would be pleading to the charge of retail fraud, 3rd degree.
Your Honor,
And
that's not correct at this time.
Oh, it's not. Okay, what are we doing?
Your Honor,
Jointly requesting an adjournment. We're in the midst of some negotiation and discussion that
Oh, okay,
another case that's taking just a little bit of extra time.
got it.
We've got a couple of weeks that. And I don't want if the court wouldn't mind, we can take the plea form back. I don't know if we're going to be entering a plea in the near future.
Got it.
Don't want the court to-
And that was probably when prior counsel was in. I'll keep the rights, but okay. So I'll adjourn this matter to. Will June 17th work for you, Mr. Hermanowski?
yes, Your Honor.
All right, June 17th, 2026, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Thank you.
Have a good day, everyone.
All right. Court does call the case, People versus Gregory Peterson.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Kyle Thompson appearing on behalf of Gregory Peterson, who stands to my right. Greg, could you state your name for the record?
Greg Peterson.
I'm almost afraid to ask, but I have a plea form. Are we doing that?
Yes, we.
Okay. The plea form indicates that he's going to be pleading guilty to the charge of failure to report an accident, the 90-day offense. And upon a successful plea to that charge, count one, as well as the citation of careless driving, would be dismissed.
And that is correct, Your Honor.
That's correct, Your Honor.
All right, may I have him sworn?
I have solemnly sworn to affirm the testimony about to give truth, the whole truth, and nothing but the truth shall be heard.
Yes.
State your name.
Greg Peterson.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of failure to report an accident.
Yes, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. You understand?
Yes, Your Honor.
Understanding that, you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty of giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 26, 2026, at the location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Were you involved in an accident?
Yes, Your Honor.
All right. What happened?
I was going into the opposite lane and I accidentally bumped into another car and then
That's fine. Did you, after you had that accident, did you immediately stop and report the accident or drive to the nearest and most convenient police station to report that accident?
No, I didn't report that to the police.
All right. You did neither, right? I asked it badly. Did you go to the nearest and most convenient police station to report that you had an accident?
No, I had not.
Did you stop and offer identifying information about yourself or render any assistance which is necessary to the other vehicle?
Yes, I did.
It gets tricky here, Judge. He did communicate with the other driver. There was some words that were exchanged and then got back in his car and left the location. The other driver then contacted the police. There was not an exchange of information.
That's okay. So you did contact the other driver, right?
We
In some way.
did have a conversation, yes.
Okay. But you didn't give identifying information about yourself, did you?
Not in that circumstance.
Okay. And you did not offer or assist way to render any assistance if it was necessary.
Not during the incident, Your Honor.
Okay. Well, when you say the incident, not afterwards, you didn't do that, did you?
Well, what happened was I got out of my car. He came over immediately, kicked a dent into the side of my car, punched me in the face and kicked me. So I got back in my car and I left. Was I bring that up?
It's, but Judge, he was.
It's going to be a day, isn't it?
Was contacted.
Counsel approach. No, it's okay.
Was contacted by law.
whole truth and nothing but the
I'm afraid to call it. Court calls the case People versus Nevaeh Krieger.
Your Honor, Raymond Cook with you.
Saxon, you're so happy to see me. I'm glad.
I am. I'm happy to. All right.
Ms. Krieger, state your name for the court, please. Nevaeh Krieger.
I have before me a plea form that can be pleading as charged, I think, to retail fraud, second degree, the 1 year offense. And there is an agreement to sentence under height. That's the court's full understanding.
That's correct, Your Honor.
That is correct.
Can I have her sworn?
testimony you about to give the whole truth and nothing but the truth. Thank you.
Nevaeh Krieger.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $1,000, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form? Did you sign an advice of rights form?
Oh, yes.
Any questions regarding any of those rights?
Huh?
Do you have any questions about any of those rights? Do you understand me or?
I understand you. Okay. She's terrified, y'all.
She's terrified? It's okay. Me too. All right. So you don't have any questions regarding any of those rights? All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense? Get over your fear.
I prepared for her very well.
We did okay on that last part. Let me get my, where's the reason I don't have,
Wait.
you know what? I'm gonna leave. I come back and start again because I don't have. Just there. On the date of January 2nd, 2026, at the location of 2000 Waters Road, Field Township, Washtenaw County, state of Michigan. What do you do at the Target store that makes you think that you're guilty?
I was in Target, Pittsfield Township, when it was open to the public, and I took like about $444.
What are you reading off of? Gave you something to read. Okay, no, it's okay. Just were you in the Target? Were you in the Target store?
Yeah.
Did you try to take something out of the Target store?
Yes.
All right. And this was merchandise they had offered for sale, and you tried to leave the store without paying for it?
Yeah.
All right. And as you said, the store was open to the public at the time, right?
Yes.
All right. And is this on value or on value? Okay. Was the total amount, you okay? Okay. Was the total amount of what you took from the store, was that in excess of $200?
Yes.
Yes? All right. Ma'am, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation report. Sentencing in this matter will be
July
8th, 2026, 9 a.m. Bond will continue. Survived. All right. Ma'am, do me a favor when you go out. Down on the left-hand side is my probation department. Stop in there before you leave the building, okay? Thank you. What, all those people came with you? All those people were with you? And you were nervous? You brought some big people too. They were tall. I don't know, you might have had to go. Court calls the case, people versus Dana Donovan.
Morning, Your Honor. Raymond Cook for the people.
This is the Raymond Cook. Did not check.
Not checked in. Given the nature of the charge, bench warrant will issue for defendant's failure to appear. Bond will be set in the, what is the alleged VAC in that?
0.108. No.
I'm sorry?
108, no crash, no priors.
Bond will be set in the amount of $10,000. She needs that.
Okay, that's the report for your recall.
What is this? That was the other one. Court calls the case, people versus Dorita Richards.
Morning, Your Honor. Raymond Cook for the people.
So Raymond Cook Council.
Dorita Richards. No response. I'll issue on this one in order to show cause. Court calls the case of the people versus Jomini Vanderloop.
Morning, Your Honor. Raymond Cook for the people.
Raymond, no counsel, not checked in.
Bench warrant in this matter will issue for defendant's failure to appear. Yeah. Bench warrant will issue for defendant's failure to appear on this one. Bond set in the amount of $5,000. Give a 10% privilege. Court does call the case, people versus a Duraman Bonda.
Morning, Your Honor. Raymond Cook for the people.
Rob Running on behalf of Mr. Bonda.
Your name, sir?
Up there, man, Bamba.
Thank you. What are we doing?
Yeah, I'm requesting an adjournment.
What's my date? 17. I'll adjourn this matter to June 17th, 2026, 9 a.m. Bond will continue.
Thank you.
Bond. Thank you. Court does call the case, people versus Rita Bryant.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Bryant, who should be appearing via Zoom.
And I am attempting to make my camera come on, but it's not. Can you send that again? It's not letting me. Okay. There we go.
There it is. State your name.
Rita Bryant.
All right. What are we doing?
We'd be requesting to set this matter for final settlement conference, Your Honor, and I would be asking to address one bond condition when appropriate.
You don't want it this Friday.
We do not have to set it for this Friday.
Jury final settlement conference will be August
7th.
August 7th, 2026, 9 a.m. Jury selection will be August 10th, 2026, 8:30. Both of those proceedings are in person. All right.
In addressing bond, Your Honor, my client would like to request for her scram tether to be removed. Unfortunately, this week she was in a car accident, which is leaving her for a great amount of pain. She would understand that if the court would like her to use an alternative means of testing, such as a SOPA-link device, or coming in to test. Just due to the unfortunate recent car accident, she's just in a lot of pain, and the scram tether is causing some extra concerns. She has not had any violations on the scram tether while on bond.
Response and brief.
I just want to make sure that there is some form of alcohol testing. I know that alcohol was involved in this incident. I'll leave it to the court's discretion whether to keep it as scram or change it to a sober link.
I'll change it to, with proof of medical regarding the accident, I will change it to a sober link tether 3 times a day testing. So you'll have to submit that to us along with an order to switch it over.
Understood, Your Honor.
All right, thank you.
Thank you.
Court recalls case People versus Gregory Peterson.
Morning again, not agreement books for the people.
Good morning, Your Honor. Kevin Thompson appearing on behalf of Gregory Peterson. Stands to my right. Greg, please state your name again for the record.
Greg Peterson.
All right. My understanding is that he's changing his plea to a no contest plea.
That is correct, Your Honor.
All right. And the basis for that is I'll indicate a lack of memory as to things. And I think it's appropriate in these circumstances to accept a no contest.
That is correct, Your Honor.
So you understand that a no contest plea means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
And you also understand that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. All the rights I explained to you apply to a no contest plea. You understand that, sir?
Yes, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
All right. Court has received and reviewed Michigan Department of State Police report for their case number 3421-26. Any objection to the court having reviewed that report?
No objection.
The people, Your Honor, may I make a brief record as it relates to that report?
Yes, sir.
Your Honor, that report was furnished to the people this morning and promptly forwarded to defense counsel. I've spoken with defense counsel. My understanding is that he's had an opportunity to review it fully. I just want to make sure that was clear and on the record for the purpose of this plea, given the recent disclosure of that report.
And that is correct, Your Honor.
That is correct. All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Sir, I do have to apprise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to set aside your plea, and the court would not be bound by any sentence evaluation or record. You understand that, sir?
Yes, Your Honor.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None from the people?
None from defense.
And have I complied with the court?
Yes, Your Honor.
Yes, you have, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Thank you. Yes. Defendants referred to probation for a pre-sentence investigation and report and consideration of any restitution.
Oh, just restitution.
Sentencing in this matter will be
July 8th.
July 8th, 2026, 9 a.m. Bond will continue. All right, sir, on your way out, if you can stop at my probation department so they can start that process. I should also indicate that ticket number 264686364 SI is also dismissed. Thank you
very much, Your Honor.
Thank you.
Thank you.
I'm gonna call the start with it.
Court calls case People versus Craig Rosecrans.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Rosecrans.
Is he here?
Yes, Craig Rosecrans.
Thank you. What are we doing?
At this time, Your Honor, I will be requesting an adjournment. Mr. Rosecrans is scheduled to be sentenced to the Runaway Recovery Court on June 12th, and that will have an impact on my negotiations with Mr. Cook here.
On June 12th, he's going to do that?
Yes.
I'll adjourn this to June 17th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Braisha Anderson.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Braisha Anderson. Your Honor, I don't see her in the courtroom and I don't have an explanation. for her absence today.
Oh,
I would note that the defendant is set for a preliminary exam on June 16th. I don't know if that makes any difference to the court's consideration.
won't be here that day either. Is that my day?
Or to have the information.
Who's that before? Me?
Let me check
I'm not here.
our case.
It's okay. Bench one release, it's failure to appear. We can address it on that day. Bond 5,000, 10%. All right. Warrant will issue me. Court does call the case. People versus Demond Brands.
Good morning, Your Honor. Trovia Star on behalf of Mr. Bransford, who's in custody.
Yes. Your name, sir?
Demond Brands.
Thank you. What are we doing?
Your Honor, I'm asking for an adjournment. I just received discovery this morning, and I was in the middle of filling out the green sheet, but I'm asking for an adjournment.
Is this the only thing holding you?
You know, he had a case this morning in Arbor, $1,000, 10% bond. He has some other cases as well. He has some cases tomorrow with you, and also 2 and 14B.
June 17th, 2026, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Yes.
Court does call the case of the people versus Spencer Rassick.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rassick, who purchased to my right. Please state your name.
Spencer Rassick.
Hands out your.
All right, what are we doing?
Your Honor, I spoke with the people this morning. 3 of us actually had the video referenced in the police report, so we're asking for a 2-week adjournment. Is that correct?
2 weeks should have to get that.
Oh, yes, more.
Motion just.
2 weeks.
Yes, Your Honor.
Adjourn the matter to June 17th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
This one. So.
Got it. Court does call the case. People versus Paul Ledger.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Please the Honorable Court, David Burgess on behalf of Paul Ledford.
Your name, sir?
Mr. Ledford.
Okay.
Your Honor, I spoke with the prosecutor this morning. There's he has a PCC up tomorrow as well as a couple of pending charges, Judge. So we're just asking for an adjournment to hopefully resolve all matters at one time.
Will the 17th work for you?
Get a bit more time. I see there's 2 pending cases in the warrant queue that would be authorized and sworn to. So hopefully
July 1st.
try and make that work, Your Honor.
All right. Adjourn the matter to July 1st, 2026, 9 a.m. I would also indicate, and I don't know if you're aware of this, counsel, he's got a warrant out of 1482.
Not aware. I'm only aware of the 2 pending, Your Honor, the PCC tomorrow and the.
It's a city case, just so that you're aware, for solicitation.
Okay. Thank you, Your Honor.
But I have and want to check right before I come in here. I don't have.
All right. Thank you.
They should have never been charged for solicitation before.
Okay. Is that a issued case?
Pardon?
That issued the warrant? Was it issued or was it pending?
The warrant.
It's active.
It's active.
Okay.
It's active.
All right.
Thank you. Court calls case people versus Jacob Simmons.
Morning, Your Honor. Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Jacob Simmons, present on the Zoom.
He's fine.
Oh, he is here.
Hello.
Sir, state your name.
Hi, Jacob Simmons.
Thank you.
Thank you, Your Honor. Your Honor, we're requesting to set this for final settlement. Prince, Mr. Simmons has indicated he wants to get me some information, so I was hoping we could do the August final settlement.
Without objection, jury final settlement conference, August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
You're all set.
Court calls case People versus Tasha Steiner.
Morning, Your Honor. Good for the people. Oh, state case, not pretty good for Connor still on township.
Yeah, right.
Good morning, Your Honor. Christina Saxon for Ms. Steiner. Steiner, please state your name for the court.
Dr. Steiner.
What are we doing?
Your Honor, Mr. Steiner made an offer. I'm sorry. Schiller.
Just all right, take a breath. Start over. Mr. Schiller made an offer.
Mr. Schiller made an offer, and I don't think he's had a chance to read my response to that. So that's why I'm waiting to see if he has a response.
Okay, so how long are we going to wait? Because I don't have all day, but apparently.
Can we pass on this?
Well, how many more do they have to test out? One back and forth.
They have to read more after this.
Yeah, we better pass it. Conrad reads slow. So,
Yeah, email. That's the bad part.
all right, if you get back, I can bring out whoever's next. Court does call the case People versus Darrell Kubiak or Kabaki.
Morning, Your Honor. Raven spoke to the people.
Morning, James Talbot on behalf of Mr. Kabaki. Gerald, please state your name for the record.
Daryl Kabaki.
I have a plea form that indicates that he'll be pleading to the charge of allowing another to violate the motor vehicle code, a 90-day offense. He'd be pleading to that added count 2. Count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That is correct, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Help you God. I do. State your name, please.
Daryl Kabaki.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of allowing another to violate the motor vehicle code. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost. Do you understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
So you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty?
Yes, sir.
March 6, 2026 at the location of westbound I-94, Pittsfield Township, Washington County, state of Michigan. Were you operating a motor vehicle?
Yes, sir.
What did you do that makes you think that you're guilty?
I was operating a motor vehicle on my way to work on 94.
Okay. So the other person or the person that you allowed to violate the motor vehicle code was yourself?
Correct.
Because you shouldn't have been operating that motor vehicle the way that you were, correct?
Yes, sir.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
You have it. What?
The court will accept the defendant's plea to count 2. there anything you or your counsel want to say before I impose sentence?
Not at this time, Judge. Just ask that the court immediate sentencing to fine and cost.
Fines and costs of $250, or 90 days suspended. When can you get that paid, sir?
Today.
Today? Thank you.
Yes, sir.
Pay that today and then you're all set.
All right, thank you.
Mr. Burdell, does that ring hurt?
Judge feels fantastic.
Okay, no, you were just playing with it. And I'm like, geez,
Just fiddling.
is it just painful for you? All right. Take care, sir.
Thank you, Judge.
Court does call the case. People versus Sean Charnley. It's not you.
This is the right.
Your name, sir?
Sean Charnley.
All right, Mr. Charnley, you are before the court on a misdemeanor complaint that alleges that on or about March 24, 2026, at the location in Pittsfield Township, that you did possess drug paraphernalia, namely a hypodermic needle and or syringes. Do you understand that charge, sir?
Yes, I do.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
I do.
First question I have for you is, do you want to be represented by an attorney?
Sure.
Okay. All right. This is a public defender case.
Yes, Your Honor. Assistant Public Defender Bukovich on behalf of Mr. Charnley. At this time, Your Honor, as it relates to the charges, will be standing mute and waiving any additional formal reading.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. All right. What would you want to adjourn pretrial date then?
Yes, Your Honor.
Pretrial in this matter will be adjourned to June 17, 2026, 9 a.m. As to bond. Are you held on anything else, Mr. Attorney? Plenty.
So I would ask for a consideration of a low cash bond for purposes of credit.
Bond will be set $1,000, 10% bond. All other standard conditions, including no assault to possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. That's all I'll set at this time. All right. Thank you, sir.
Your Honor.
Court calls the case of the people versus Sapovan Hard Tops.
Your Honor. Henry, that's what we got the township in the matter. Bringing sugar to the people on file.
And Your Honor, Joe Simon, what happened? What happened?
What? Like the same height. I'm just shocked. I'm sorry.
I walked in. I walked in.
That was unnecessary.
I walked into it. Joe Simon on behalf of defendant said typo.
There you go.
Say your last name as well. Got that.
Okay. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating 93-day offense. Upon a successful plea to that charge, count one would be dismissed.
Your Honor, that's true. We're also here for an arraignment.
Arraignment. Hold on a second. Was there an added count to this? No, the only reason I'm saying is pleading to an added count 3, count 1 would be dismissed. I don't see a count 2.
That might have simply been a type of record.
Oh, it should be that he's pleading to the added count 2.
True.
Count 1. All right. And then you said you're also here on an arraignment?
This is an arraignment free trial, Your Honor. Yes.
It is. Okay.
Okay.
So as to the arraignment.
Waive formal reading, stand mute to the charges, and at the right time, we have a travel request.
Defendant every way formal reading, standing mute, court will enter not guilty plea. I have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, nothing but the truth of God? State your name.
Typo, that's all. All right.
Speak up a little louder.
Yeah. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. Court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
And still wish to plead?
Yes,
And to that charge, how do you plead?
yes,
How do you
And by pleading guilty, you will not have a trial. Okay.
plead guilty.
Pardon?
Plead guilty, Your Honor.
He didn't say the word guilty, Your Honor, so now he's clarifying.
Okay. You understand that you will not have a trial of any kind. You signed an advice of rights form?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense? On the date of March 14, 2026, at the location of 3000 Woodland Hills Drive, Pittsfield Township, Washington County, State of Michigan. Well, actually on Packard Road, I think, near Oakdale. Were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume an intoxicating? What'd you have and how much?
Had some beers and some shots, Your Honor.
All right. Were you stopped by the police? Or was there an accident?
No accident, Your Honor.
Okay, you were stopped by the police?
Yes.
Why'd they stop you?
I was changing lanes, Your Honor.
Lane maintenance.
Lane.
Okay. So some type of erratic driving as you were going back and forth? Okay. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes.
And what were the results?
0.179.
0.179.
Do you have any reason to dispute those blood test results?
No. No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to apprise you that if I accept your plea, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that? Counselor, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. All right. Defendant is referred to Bounce Works for an alcohol screening and assessment. And
But they don't, the court, he's done that. So
done that, that's right. And the victim's impact panel sentencing will be July 8th.
Your Honor, can we have the very next session? I will be traveling on July 8th. I'll be driving. Maybe I, zoom in from the car or something. Be better.
This is a trip your lovely wife is making you take?
Yes.
Then permission is granted.
Thank you, Your Honor.
July 22nd, 2026 at just noon or 9 a.m. All right. Bond in this case, I will set the defendant's bond in an amount of $20,000. Person of Lord excluding no assault, favor presenting weapons. He's also not to possess any alcohol, recreational marijuana, or any illegal drugs. I will also sign a community corrections order. He is to be placed on the sober link testing device.
Your Honor, just look at please.
I do. All right. That's what I was going to ask.
Your Honor, with respect to that travel request.
Yes, sir. I thought it was yours, but go ahead.
Well, now my client has prepaid travel to Colorado from June 12th to June 5th. He was fully expecting the community corrections referral. He knows that he would have to test while away if the court grants him permission. And he's going to make sure that he's adjusted to time when he's traveling.
Beautiful state, so I'll let him go.
Thank you.
I'll indicate the defendant may travel to Colorado. What were those dates again?
June 12, return June 15th? 15th, yeah.
12th through the 15th?
Yes, yeah.
All right. June 12th through June 15th. All right. That's it.
Thank you, Your Honor.
Thank you.
Wait for me. I'll stay in that conference room.
What calls the cases? Is that it for you, Mr.?
It is. Thank you, Your Honor.
Have a good day. Court calls case People versus Shannon Giesling.
And Assistant Public Defendant Nicholas Buckovich, I'm having Ms. Kiesling.
Headphones.
Right. Needs the headphones, Your Honor.
That's right. We need.
I'm sorry, Your Honor. Truth clear. Truth clear on me. Your Honor, Eastling was scheduled today for a review hearing for the board to check the status of for the inpatient treatment. I have correspondence that both myself and counsel received from the jail that assessments, access sub-assessment days and Fridays. And she is on that list to be completed. It was my understanding last week that she was second on the list. So it's my anticipation that that would be completed today or this Friday. I have not got that in writing that that's what it would be this week, but that's my interpretation.
Yes, Your Honor, and I have been following up with Ms. Sarah Stewart along with Ms. Ferrara. I also have been speaking to Ms. Kiesling's family. They did find a place in Brighton that would be able to take her insurance to receive inpatient treatment. However, she would have to be released prior to that being able to be done because there's obviously questions for the assessment that they cannot answer on Ms. Kiesling's behalf. So obviously, I know Ms. Kiesling's family planned to be here today and has been here in support. So I understand she does have the support, but obviously I was unable to get anything really moving in motion without having them be able to speak to my client directly.
All right. What I will do, I think, in this case is if you get that information and that's satisfactory, prepare an order for her release. But I need some documentation that that's a place that she could go to do treatment.
Your Honor, it's kind of tricky. It's kind of tricky with that because a treatment facility is not going to be able to say that yes, they have a bed.
Correct.
For her until the assessment is completed. So that's where
Looks real.
yeah. So there could be, if she's released, there could be some delay with an appointment. And depending on how that assessment works for them, whether she would be assessed for the bed. Does that make sense?
Yes. The facility does its own assessment, right?
That's my understanding.
Can you
Yes. I guess. Court does call the case People versus Tanisha Moore.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Moore. I believe should be appearing via Zoom.
Yeah. Township.
I did speak to Ms. Moore, and I know I provided the plea agreement in the court. So I believe she was supposed to be here today.
Tanisha Moore, she's not here.
If I could briefly pass this matter to try to contact my client.
Was she coming in person?
Yes, I know we received permission to Zoom, and that information was provided.
Fine. I wish I didn't like you. Court calls case People versus Quantity Thomas.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Thomas.
Your name?
Clay Thomas.
What are we doing?
At this time, Your Honor, we'd be asking for an adjournment. We are trying to work out a global resolution of these and have pending cases in the circuit court.
When's your next circuit court date?
I believe that was adjourned out about 2 weeks. I believe it may be the 15th. I would need to look at those cases.
So if I adjourn it out to the 17th, we're good.
Yes, we'll try to work out. Yes.
June 17th, 2026, 9 a.m. Bond continued. Thank you. That was,
They're going to bring the recap up next.
okay, so they're ready on that.
Yes.
So court does call the case People versus Ryan Brown.
Counter and so on that. So Township.
Raymond Cook for the people.
23.
Ryan Brown.
Christina Saxon, 0610.
Ron Brown appearing on behalf of the other.
Okay. Your name, sir? Ryan Brown. What are we doing?
Requesting adjournment, Your Honor.
Your Honor.
June 17th, 2026, 9 a.m.
Thank you.
Bond gets.
Thank you.
Court does call the case People versus Pastor Shiner.
Counter and so on yes.
Good afternoon or morning, Your Honor. Tina Saxon from Ms. Shiner.
Your name again?
Pastor Shire.
Thank you.
Your Honor, we're asking for an adjournment on this. And Your Honor, can we set this out for about a month? Because
I don't mind doing that if council believes that's appropriate, but is she being held on something else?
yes, Your Honor,
Oh.
multiple cases with dates the end of June and July 7th. Our next hearings in 14B. And
Said July 7th?
June 30th and July 7th
Yeah.
are her next hearings there.
So you want this after those or?
Yes, Your Honor, we're trying to get a resolution.
I got you, but. So what would be my July date after the curve? July 15th. I'll adjourn the matter out to July 15th, 2026, 9 a.m. Bound continued.
Your Honor.
That it for the jail?
Yes, Your Honor.
All right, thanks, guys. Court calls case People versus Russell Norvell.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Russell Norvell.
Your name, sir?
Russell Norvell.
I have a plea form in front of me. Is that what we're doing?
Yes, Your Honor.
Indicates defendant will be pleading to two charges, counts 3 and 4, retail fraud, third degree, both 93-day misdemeanors. Upon successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
May I have him sworn?
Yeah. Now let me swear in affirm. The whole truth and nothing but the truth you got.
Yes.
State your name, please.
Russell Norvell, the second.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges of retail fraud in the 3rd degree.
Yes.
Is that correct?
Yes.
Those are misdemeanors, punishable by up to 93 days jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty to these, sir?
Yes, sir.
To the charge of retail fraud, 3rd degree as contained in count 3. How do you plead?
Guilty.
To that same charge as contained in count 4. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I understand.
You signed an advice of rights form, is that correct?
That's correct.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Does anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Sir.
Date September 17, 2025 at the location of 3825 Carpenter Road in Pittsfield Township. What do you do at the Meyer that makes you think that you're guilty?
I tried to leave the store without paying full price for the items.
Okay. So without paying full price, what do you mean?
Tricking the scanner, I guess. So it rang up just not correctly.
So did you switch tags or something or?
No, it was like a light paper crimp.
Pardon?
A light paper crimp angle, just the way that you would kind of brush it across.
Okay. And so you were manipulating
the
tag for the scanner to read in some way.
Yes.
And that resulted in the scanner giving a lesser price.
Yes.
Than what the item was actually worth.
That's correct.
Okay. And maybe, did you do that on 2 occasions at least? On that day?
Yes.
The date.
Yes.
So you did that twice?
I did.
All right. And then you tried to walk out of the store without paying for the item?
Yes.
Is that correct? And the store was open to the public at the time?
It was.
You didn't have anybody's permission to do this, did you?
No.
And okay, I don't need to value. All right. Sir, I do have to advise you that if between the time I accept your plea to these charges and your time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would not be bound by any sentence evaluation or recommendation, and you could not withdraw your plea. You understand that?
I understand.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None of the people.
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to counts 3 and 4. Counts 1 and 2 are dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 8th, 2026, 9 a.m. And will continue. Thank you. Sir, on your way out, please stop down in my probation department and check in so we can start the process.
Okay.
Thank you, Your Honor.
Thank you. Now there it goes. Court does call the case People versus Mohammed Mufud.
Your Honor, Randy Cook for the people.
David I. Goldstein appearing on behalf of the defendant.
Mohammed Mufid. Thank you.
May I approach the clerk, Your Honor?
Second. You know, they haven't fixed that. Whatever.
Do you want?
Yeah, we're gonna have to because.
May I approach with Mr. Cook, Your Honor?
May.
And I'll prepare an order, Your Honor.
Okay, and I'll indicate if a defendant may travel.
Now, the other is that.
France?
Yes.
Monaco.
Well, Monaco, he's going to the Grand Prix, I believe. Is that right?
No. The horse show. You're really going to Monaco. Okay.
Well, right. But,
no, I get it now. Okay.
Yeah, but I mean, it's, he steps over the boundary and I don't want to be any issues. So I said France.
That's fine.
France is bigger.
And that was July
8th through the 12th.
July 8th. July 12th. All right. Yes. And the other issue.
Okay. The other issue, Your Honor, is that we're asking for a final settlement conference. I was told by Mr. Cook that it might be quite a while. I just indicated to the court that my client would like the earliest date possible.
Okay. The way they're selected here, the earliest date possible at this point is going to be August 7th.
Yeah.
For final settlement conference. Then if there has to be a jury, it'd be that following Monday.
We don't anticipate there will be, but okay.
Correct. But that's the earliest that I have in that regard. Okay, sir.
That's at 9 o'clock, Your Honor.
Yes, jury final settlement conference was set August 7th, 2026 at 9. Jury selection August 10th, if necessary, 2026 at 8:30. With the exception for the travel to France, bond will continue. And those proceedings are in person. Okay.
Thank you, Your Honor.
All right. Thank you. Safe travels.
Thank you, Your Honor.
Court calls case People versus Aaron Burrows.
Morning, Your Honor, Randy Cook.
Ron Brown appearing on behalf of Aaron Burrows here.
Gotcha.
Don't know where he is. Bench warrant will issue for defendant's failure to appear. It's just a bond will be set in the amount of $5,000. I'll give a 10% privilege. He does have another warrant out, so court will close the case People versus Shamika Kurtendahl.
Morning, Your Honor, Randy Cook for the people.
Ron Brown appearing on behalf of Ms. Burton. She on Zoom.
Shamika Kurtendahl, she's on Zoom, but Kurtendahl.
Yes. Hi.
Hello. I'll need you to turn on your camera and tell me your name.
Can you guys see me?
Yes.
Shamika Kurtendahl.
All right. What are we doing?
Your Honor, I'm requesting one last adjournment. I got the plea form. I just got to get her to sign and go over to vice
June 17, 2026, 9 a.m. bond continue.
Thank you.
Thank you.
I'll see you then, Ms. Kurtendahl. I'll call you.
Court calls the case People versus Mark Davis.
Your Honor, Randy Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Davis, who should be appearing via Zoom.
Davis,
Hi,
state your name. State your name. Thank you.
Where's my camera?
We are doing a plea today, Your Honor.
Back.
Mr. Rivas. Fourth. One second, Your Honor, I apologize.
I have nothing. I don't have any advice or rights form. I don't have anything.
I apologize, Your Honor. I did not email this to the courts. My plan was for a plea today, so I would ask for a brief just to be able to get this paperwork over to the court.
During the matter, June 17th, 2026, 9 a.m. bond continued. Thank you, ma'am. Court calls case People versus Nia Hall.
Assistant Public Nicholas Bukovich on behalf of Ms. Hall.
Hi, Nia Hall.
Thank you. I have before me a plea form that indicates that they will be no contest to the charge of retail fraud third degree. The 93-day offense upon a successful that charge count one would be dismissed. There's a sentence agreement to a prosecutor's deferred. That is the court's full understanding.
That's correct, Your Honor.
Yes, Your Honor.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Nia Hall.
All right. Ma'am, it is this court's understanding you're going to plead no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it that you need to understand. I need to make sure that you understand is it means, first of all, that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea?
A potential civil liability, Your Honor.
All right. So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes.
Any question regarding any of those rights?
No, sir.
All right. Looking at paragraph 5, you understand that you're giving up those rights, which are your trial rights, as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense? Or
yes.
Don't answer that.
No.
All right. The court has been provided Pittsfield Township Department of Public Safety report for their case number 25-26574. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you between the time of my acceptance plea and the time to commit misconduct defined into the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count 2 No contest. 2 count 2 retail fraud. Third. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 8, 2026, 9 a.m. Ma'am, if her bond will continue, if you could wait, we have.
Yes.
All right. Need you to wait there for a moment. We're going to put you into a breakout room with my probation department so we can start the sentencing process, okay?
Thank you, Your Honor.
Thank you. Court does call the case, People versus Nicole Henderson.
Morning, Your Honor. Randy Cook, People.
Your name?
Nicole Henderson.
You are before the court on a misdemeanor complaint that alleges that on or about April 12, 2026, location of Gulfside Road near Washington Road, that you committed the offense of operating while intoxicated or impaired, second offense. You understand that, ma'am?
Yes, sir.
That is a misdemeanor punishable by up to 1 year in jail, $8,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
Public defender case.
Ron Brown appearing on behalf of Ms. Henderson, waive reading stand, request adjournment.
Defendant every way from a reading standing mute, court will enter a not guilty plea. Pretrial will be set for
June 17th.
June 17, 2026, 9 a.m. Has the bond.
May I approach, Your Honor, with the prosecutor?
I would also ask to approach, Your Honor.
Yes, you will.
Thank you.
$150 attorney fee.
Y 150 honorarios de abogado.
That totals $525.
Son un total de $525.
I'm not going to put you on a probation.
No le voy a colocar en un plazo de libertad condicional.
I don't know if this will come to the attention of the Immigration Service or not.
No sé si esto le llamará la atención del Servicio de Inmigración o no.
I'm not going to call it to their attention.
Yo no les voy a llamar la atención a ellos.
But you're going to jail.
Pero usted va a la cárcel.
Minus good time.
30 días menos el buen tiempo.
Which will get you out in about 25 days.
Y usted saldrá más o menos en 25 días.
All right, you can go with the officer.
Ya puede acompañar el oficial.
You're entitled to a refund of some of your bond money. You posted $765 of bond.
Usted tiene derecho a un reembolso de parte del dinero que usted pagó de fianza. Usted pagó $765 de fianza.
So I believe $240 is going to be returned. Perhaps your family can deal with that at the counter.
Y le van a devolver $240 de lo de fianza. Tal vez su familia pueda recibirlo en la ventanilla.
I see this matter as very serious.
Veo que este caso yo veo que ese caso es muy grave y es uno que amerita una sentencia de cárcel.
I'm reluctant to place people who don't have lawful residency status on probation.
Trato de no colocar personas que no tienen su situación migratoria regularizada en un plazo de libertad condicional.
And I don't want a probation in this case anyway.
Y no quiero libertad condicional como quiera en este caso.
All right, you're going to go to the jail. If you want to give your wallet or keys or anything to your family, the officers will let you do that.
Usted va a pasar a la cárcel. Si quiere entregar sus llaves, su billetera a su familia, los oficiales le dejarán hacerlo.
Thank you, Vivian.
You're very welcome, Your Honor. Thank you. Have a good day.
Ms. Smith is present, as is Mr. Young.
All right.
Understanding, first of all, that there is, as to her bond, that there's a prior offense in 2022. There is a current pending drunk driving from I think it was 2025.
Correct.
2025. Out of that, and this becomes important, that case is still open. There is also, from, I believe, that offense, an implied consent violation. And out of that implied consent, her license or driving privileges in the state of Michigan were suspended from the date of, I just want to make sure I have the dates correct, but it.
Oh, July 20.
From July 12th, 2025 to July 11th, 2026. So as we sit here today, her driving privileges are suspended. I then have that, so in April of this year, this alleged offense, she was issued a 625G, but she cannot drive on that 625G because of the implied consent. She had no license at that time. At the time that this offense allegedly occurs, she also then has an open drunk driving case out of another jurisdiction and has the prior. And then she is here allegedly in this case with a 0.235 blood alcohol level. Ron, is there anything you want to say on behalf of your client regarding bond before the court fixes bond?
Your Honor, she's employed at General Motors in Lansing. She has a 4-year-old daughter that she cares for. She works from 10 p.m. until 6 a.m. I've mentioned sidebar that she does have a prepaid, pre-planned trip before all of this. And I'd ask the court to consider a reasonable bond in this case so she can save her job and take care of her 4-year-old. A scram monitoring device.
Anything from the people?
Your Honor, not to recount everything that was discussed at the bench, I have significant concerns for this defendant's ability to remain sober or compliant with her bond conditions. I also have concerns about her returning to court at future dates, given the multiple warrants and given that she knew that she had those warrants at the time of this offense and it told the officers essentially she was on the run from those warrants for reasons discussed at the bench, which again, some of those are private, I'm not going to get into on the record, as well as those reasons. I would ask this court set a relatively significant cash surety bond with, if the defendant were to post that bond, scram and GPS tracking tethers in case she does fail to appear, we can at least know where she is at that point.
However, standard conditions, including no assault behavior, possession of any weapons, firearms, ammunition. I will also indicate that the defendant is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. You do understand that, ma'am?
Yes.
I'm going to say I consider, given all of those circumstances, that the defendant is a significant risk to the public as well as to herself because she cannot stop drinking and then operating a motor vehicle. It just seems at this point she is fortunate that she hasn't taken somebody out. She's a 0.235 at this instant, with a pending drunk driving and a prior, all occurring within the last 7 years. She's not supposed to be driving because she doesn't have a license because she didn't take a test on one of these occasions. And the only license that she would have would be a 625G permit, which she can't drink and drive on. She's not supposed to be drinking and driving. Since I consider this defendant to be a significant risk to the public, so we can try to figure it out, her bond is set in the amount of $1,000 cash surety bond. The defendant is remanded. She must be placed, if she posts that bond, on a scram tether and a GPS tether prior to her release. Defendant's remanded.
Court date?
Thought I gave you one. June 17th, 9 a.m.
Thank you.
Location track.
Location track. Court calls the case, People versus Pajiter. Your
Morning, Your Honor. Raymond Cook for the people.
I know I mispronounced it.
Yes, Your Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Avezza, who should be appearing via Zoom. I have spoken to Mr. Avezza. He was having some issues logging into Zoom this morning. I did have him working with Kristen. I know, Your Honor, it's not my day apparently. But I do want to know he has been in contact with me. He did miss a previous PCC date. However, I did file a bench warrant recall and have this matter. He is clearly being in contact with my office. I would be asking for the consideration of an adjournment at this time.
You on his felony, you did a.
I did a bench warrant recall, which was approved by you, Your Honor. So obviously,
oh wow, you just gotta throw that out there, aren't you? June 17, 2026, 9 a.m. I gotta find a way to stop liking.
Thank you, Your Honor.
Court calls the case, People versus Jessica Mitchell.
Your Honor, Raymond.
Ron Brown appearing on behalf of Jessica Mitchell.
Ms. Mitchell, can you state your name, please?
Jessica Mitchell.
Thank you, ma'am. What are we doing?
I'm requesting adjournment. We sent over a mitigation report to the prosecutor's office.
Last adjournment I had indicated was our last adjournment on this matter.
Can we set it for trial in August?
Jury final settlement conference in this matter will be set August 7th, 2026, 9 a.m. Jury selection, August 10th, 2026 at 8:30. Both of those proceedings are in person.
Thank you.
Yeah. Court calls case People versus Anthony Rabago.
Your Honor, Raymond Cook.
Ron Brown appearing on behalf of Mr. Rabago. Just be on Zoom.
That's right.
Oh.
Your name, sir?
Anthony Rabago.
Your Honor, can we set this trial in August?
Jury final settlement conference will be August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026, 8:30. Both of those are in person.
Thank you.
On continue. Court calls case of the People versus Isha Moore.
Morning, Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Moore.
Hello.
Hello.
Yes, Tanisha Moore.
All right. This is the recall.
Yes, Your Honor.
I have before me a plea form that indicates she's going to be pleading as charged of the retail fraud second degree, the 1-year offense. That's the court's full understanding of the agreement. She's pleading no contest.
Yes, Your Honor.
That's correct, Your Honor.
Ms. Moore, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes,
State your name again for the record.
Tanisha Moore.
All right. Ms. Moore, it is this court's understanding that we're going to be pleading no contest for the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes,
Do you understand what a no contest plea is?
yes,
First thing about it is it means that you're not further desirous or wanting to contest this charge. You understand that?
yes,
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
yes.
Basis for the no contest plea.
Central civil liability, Your Honor.
Ma'am, to the charge of retail fraud, second degree, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Correct.
You signed an advice of rights form or had one signed on your behalf?
Yes.
You have any questions regarding any of those rights?
No.
You understand that you're waiving or giving up those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I will be.
Pardon?
Not right now, no.
She was sentenced to some other matters, so she was not on probation or parole at the time of this offense, Your Honor.
Was not.
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed, well, no, I won't say that. Never mind, don't answer that question. Court has been provided Pittsfield Township Department of Public Safety report for their case number 2420446. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which courts could determine the defendant's guilt of this offense. Counsel, ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Okay.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty in this case. Defendants referred to probation for pre-sentence investigation and report and determination for restitution, if any. Sentencing in this matter will be July 8th, 2026, 9 a.m. Bond will continue. Ma'am, I'll need you to wait on the line. I'm going to put you into a breakout room with my probation department so we can start the sentencing process.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
My next block right now.
11 a.m.
Okay, let me try to take some of them who are here. How many do I have?
Look, I can't see. Not a lot. This is the smallest one. 13.
13. Is it Spanish English?
One at the end.
Court does call the case People versus Pauline Schoner.
Good morning, Your Honor. Raymond, people.
This is the public defender, Nick Bukovich, on behalf of Ms. Schoner, who is now approaching. And can you please state your name for the record?
Pauline Shaner.
Shaner, that's right. Yeah, I knew that. All right, I had before me a plea form that indicates that she is going to be pleading to an added count 2 of retail fraud 3rd degree, the 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. There is a sentence agreement of no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
All right, may I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Pauline Shaner.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud 3rd degree. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
I do, Your Honor.
I should also advise you that the fine could be increased if there's some value of the property taken. If that's greater than $500, that would become your maximum fine. You understand that?
Sure, Honor.
All right. Do you understand what a no contest plea is?
Yes.
2 things about it. I have to make sure you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
And to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Your Honor.
You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights of that form.
I say yes.
Yes, sorry.
You understand you're giving up your right to appeal of right.
I'm sorry, I do.
You're giving up your right to appeal of right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 26-365. Any objection to the court having reviewed that?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Stand, Your Honor.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 8, 2026, 9 a.m. Bond will continue. Ma'am, on your way out, on the left-hand side is my probation department. You could stop in there and check out before you eat.
I will. Thank you.
Thank you.
That's sorry before July 8th, right?
Court calls case People versus Peter Vasher.
Your Honor, reading to the people.
And good morning, Your Honor. Christina Costantino appearing on behalf of Peter Vasher. Judge, I don't know whether he is on or present in your courtroom, unfortunately.
Peter Vasher. Did he check in? He did not check in, counsel.
Okay, Judge, I would be asking the court to consider setting this perhaps for a show cause hearing. I was just appointed yesterday, so I'm not sure whether Mr. Vasher does or does not know about this hearing date. I do represent him in another separate matter in which he was just in court last week for that matter. So I'm not sure if he's aware of this court date or not, but I would ask if the court would consider setting this perhaps for a show cause.
Do I do that? No. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. What I will do is I will not issue the warrant until, what's today? I won't issue the warrant until the 5th, counsel, until Friday.
Thank you, Judge. I appreciate that. And it was worth trying.
Yeah, I know. You and Mr. Daddy. And I'm consistent in saying no. All right.
Thank you, Judge. Have a good rest of your day.
You do the same. Court does call the case. So the People versus Sierra Sutter.
When you're on reading to the people.
Show cause and no counsel, not.
Sutter. No response. Bench warrant will issue for defendant's failure to appear. Bond $5,000, 10%. Court does call the case of the People versus Jalen Washington.
When you're on a reading to the people.
Rob Brown appearing on behalf of Mr. Washington.
Sure, your name?
Jalen Washington. I'm requesting adjournment. We just got an offer in this case, Judge, this morning.
Well, I had already put last adjournment, but.
Well, we set it for final settlement in August.
Well, do you have an offer that may be accepted? Is that the deal?
Well, we want to go through the details of it. I just talked to my client about it. I just got it.
June 17th, 2026, 9 a.m.
Thank you.
Court calls case 2 versus Tyler Redmond.
This is an arraignment with no counsel. I've not heard from the
I'll issue an order to show cause on that. Court calls case People versus Ryan Atkins.
and it's still around, yeah.
She here. That's weird. Ryan Atkins.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Atkins. I apologize, Your Honor. Give me 1 second.
You know where he is?
And you know where Mr. Atkins is? No. This is a Mr. Brown case. I'm stepping in, Your Honor.
No, it's okay. Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. Court calls case People versus Fantasia, I think Allen.
Township.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Allen.
Spontaneous Evelyn here.
Thank you. All right, what are we doing?
I reached out to Ms. Allen who left a voicemail, but I did not receive a call back, so I didn't have contact with my client before today's court date. I'll be asking for an adjournment.
Turn to matter July 1st. Is that my day? July 1st, 2026, 9 a.m. Ma'am, get in touch with your attorney.
Yes, Your Honor.
Oh, I'm sorry, man. Court does call the case People versus Johnny Barney.
And it's still around again.
Ron Brown appearing on behalf of Mr. Barney.
Barney, unmute. State your name, please, sir.
Johnny Barney.
Thank you.
Your Honor, I'm requesting a 30-day adjournment so he can clear his license.
July 1st, 2026, 9 a.m. Bond continues.
July 21st.
Court calls case People versus Ashton Busby.
And it's still around again. Susan Ryan, we know counsel.
I'm here.
Hello, Mr. Busby. I'll need you on camera, sir. Where is he? Oh, there he is. State your name.
Ashton Busby.
Busby, you are before the court on a misdemeanor complaint or citation that alleges that on or about April 18, 2026, location of Washington Avenue in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while your driver's license was suspended, denied, and or revoked. Actually, the driver's license was expired.
Yes, sir.
Do you understand that charge, sir?
Yes, sir.
That is a misdemeanor, punishable by up to 90 days jail, $100 fine plus court costs.
Yes, sir.
Do you wish to be represented by an attorney on this?
Yes, please.
It's a public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Busby. At this time, Your Honor, we will waive any additional formal reading of the complaint and be standing mute as to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Retrial in this matter will be adjourned to
June 17th.
June 17th, 2026, 9 a.m. Defendant's bond is set at a $5,000 personal recognizance bond. All other standard conditions include no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. You understand all of that, sir?
Yes.
All right. Thank you.
Mr. Busby, I would ask that you call our office so we can get contact information.
So, Mr. Busby, you got something to write with?
Give me 1 second.
Thank you.
All right, I'm ready.
All right. Need to call area code 734-222-6970. That's the public defender's office. Make sure to give them a valid email and phone number.
Yes, sir.
All right, do that right away.
Yes, sir. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case People versus Diamond Byers.
Township.
Ron Brown appearing on behalf of Ms. Byers.
Diamond Byers. Where is she? Oh, there she is. She is. Oh, okay. She's. Wait, okay.
I'm requesting.
I'm gonna adjourn it out. I'll adjourn it out to July 1st, 2026, 9 a.m. All right, we can type that expires and let her know that I did that. Court does call the case of the People versus Brandon Klein, 2 cases.
Yes.
Ron Brown appearing on behalf of Brandon Klein.
Both these.
Sir, if you can unmute and state your name.
Brandon Klein.
Thank you.
Ms. Smith can wait. Let's do Mr. Young.
And if you would like to take Mr. Truckey's matter, Mr. Young is not until 11.
All
I'm
right.
happy to
You want
see
to talk to Ms. Smith?
What's that?
Do you want to talk to her?
Yeah, I will talk with Mr. Young. If he has a report to read.
Well, let's do Mr. Truckey's case. That was on me only.
Your Honor, if I could approach.
Yes. That's good news. This is file number 265330FY, People versus Rayanne Ross. She's here with her lawyer, Mr. Ross Truckee. Miss Ross was arrested when they executed a search warrant at a house in Three Rivers on March 22nd. I think she's hanging around with the exactly wrong people. Anyway, she had some methamphetamine that was attributed to her and she accepted ownership. She pled to use of methamphetamine and Mr. Truckee indicated he would be asking for 7411 conditions. He's here today. He's provided me with a recovery program attendance log and a bunch of notes from Pivotal. So that's good to know that she's plugged into some services. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. Ms. Ross has made my job easy. She got plugged into recovery services as soon as she bonded out of jail. She took accountability for her substance use disorder and the criminal aspect of it. She stayed in regular contact with me. She's made her court appearances. She's not relapsed. So often you see someone in her situation catch 2 more charges because after being arrested once, you start to glow bright red. But she's not.
Didn't we test her on the day and she was negative when she was, that was the other.
She's willing to take a test today.
No, I think we're good.
But for those reasons, and because of Ms. Ross's lack of a criminal history, we'd ask for 7411 probation to put up some guardrails for her to continue walking her recovery path and to hopefully put this part of her life in the rearview mirror for good. I'd ask that you also consider reducing any discretionary fines as Ms. Ross isn't currently employed, although she is seeking a change in that circumstance, and to allow her to continue forward making progress. Thank you.
Are you still at the 5th Street address?
No, sir.
Which was a drug house, and so you needed to get out of there. Where are you now?
In Three Rivers at a friend's house.
Okay, but you're not with Mr. Fraze anymore?
No, he's in jail.
Yes. All right, what would you like to tell me?
That I know I messed up in my life and this was like a wake-up call for me and my addiction. And that I'm glad that I was recommended Pivotal because I've learned so much through IOP and they're very caring and supportive people over there.
Are you plugged in with community corrections? Seeing the ladies from community corrections?
Yes, she was subject to community corrections on pretrial release, I believe.
So you're checking in with them?
I talked to him at the jail when I was there.
All right. Well, Mr. Truckee, I think this case is appropriate for 7411 probation. The prosecutor's not here to provide input, but I suspect they don't disagree with that.
I guess for clarity, Your Honor, the pretrial release order does not indicate community corrections.
Okay. I'm going to put you on probation under section 7411. We're going to do 12 months. You did 1 day in jail, I think. You got arrested on the 23rd, 22nd, bonded on the 23rd. I'm going to order 31 days jail credit. 1, of the 31 days ordered, 30 are deferred. So there's some jail hanging over your head, but if you do what I ask you to do, there won't be any additional jail time. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 probation oversight fee, and $480 probation oversight fee at $40 a month. $755. You are to do drug and alcohol testing as directed, continue your substance abuse counseling and treatment, sign a release, abstain from the use of alcohol or any other controlled substance. Do you use marijuana?
No.
All right, so that won't be an issue. I mean, marijuana is lawful for adults if they want to use it for recreational purposes, but when you're on probation, we prohibit it. I think you've taken some really good steps, not the least of which is having your partner locked up so he doesn't have access to provide you with narcotics, or at least methamphetamine. You moved, you're going to Pivotal, you're going to support group. It's hard, they don't have a lot of NA groups. And a lot of the NA is focused on fentanyl and heroin and opioids. We don't have a lot of meth people doing support, but you're trying to do what we got. I don't have a probation referral form handy, but I'm just gonna have the officers sit you out to the counter. One of the probation officers will do an intake here in a bit. I'm gonna attach all this stuff that you gave me so probation can see how you're doing. Okay. All right, you might have to wait out in the hall. All the probation agents are here, but at least they're already in this building. So you go out and check in at the counter and they'll meet with you in a little bit.
Thank you, sir.
Talk with everything, man.
Thank you.
Thank you, Your Honor.
All right, let's take up the matter of Jameer Young. Good morning, John. Good morning. This is kind of an odd case in that it's almost 3 years old. The file number is 231446SD. Mr. Young has very minor criminal history. He got arrested here in 2023 for a drinking driving incident, which frankly was not real good. And we lost track of him for several years and caught up with him recently. He's here with his lawyer, Casey Strong. Ms. Strong, what would you like me to know?
Thank you, Your Honor. As the court already recognized, this case is from 2023. During the pendency, Mr. Young has not been in any trouble. He has been working and living his life. As this approached, he did take significant steps. He had a substance abuse assessment completed. He started following those recommendations. I will allow him to speak more to that. As indicated, we understand that the presumption in impaired cases is fines and costs, but understand and recognize the court's ability to overcome that presumption. I would like to note from Mr. Huff's report that Mr. Young was sleeping in the back seat and he woke up to officers outside his car in 2023. He took responsibility for this immediately, which is reflected in the plea agreement from the state. The recommendation is 2 days jail credit, 1 day to schedule 24 hours on the weekend. With understanding of the facts, I would ask the court to follow that recommendation, looking to the jail's limitations on scheduling and considering that as well. Thank you.
Well, you drove from where you live in Indiana to Grand Rapids, picked up your brother-in-law, and drove all the way back from Grand Rapids, where you went off the road south of Three Rivers on 131, nearly killed you and your brother-in-law. Ended up in a field. Facts are bad. Your blood alcohol is 0.15. Mr. Matt Huff prepared the screening report and points out some of the issues I just addressed. Mr. Huff, what's your thought here?
Well, as it's been stated amply so far, this case is strange. It's from 2023. It involves somebody who doesn't live in our county, who lives 2.5 hours away down in Converse, Indiana. On its face value, the case is pretty aggravated in the sense that it would involve the property damage accident where he left the roadway. Obviously, there's inherent risks when you're driving drunk, and this was a vivid example of what can go wrong. With that being said, Mr. Young appears to be taking responsibility. He wants to get his driver's license back. He wants to get his life on the right track to where he can do the things he wants to do, and that requires him to take responsibility for this action. So he has not been in any trouble since. He doesn't have a lot of extensive criminal history. I mean, I noted in the report, technically he qualifies for probation. I just don't think that it's really gonna be feasible for somebody who lives 2.5 hours away. There's got to be a consequence for actions, even if they are 3 years dated. Otherwise, everyone would just take off.
The reason it's 3 years old is he didn't show up for his arraignment.
Right. Otherwise, everyone
blew
would
off
just
the
not.
arraignment, and then several years later, he calls and says, "Hey, my license is suspended." Well, I guess so. That's what restarted it. Now, he didn't show up for 3 years, but he did, I think he called us and made arrangements to come in. But the reason it's 3 years old is because he didn't show up.
Right. So I made a recommendation for some scheduled jail. He's worked at a position or at a Walmart distribution facility for a substantial amount of time. He takes care of his family. If that punishment is to be enacted here today, as far as a jail sanction goes, I think that the court could schedule that.
Well, Ms. Strong just told me something I hadn't heard before, that he's done some treatment and got some evaluation stuff. Did you know any of that?
I don't believe I was aware of that, but I'm open to.
I'll let Mr. Young speak to that.
Mr. Young, let's hear from you.
Yes, sir.
Go ahead. What would you like me to know?
Well, since this, I've taken the measures to obtain my driver's license. I currently hold a CDL within the state of Indiana. I had conversations with my pastor at my church regarding this and other matters that I'm currently facing, not me personally, but within my family. So I'm just really trying to take care of that.
All right, well, you said you got an evaluation?
I'm sorry, sir?
You got an evaluation?
Yes. I've talked to, besides of talking to the probation, Mr. Huff here, I had a conversation with my pastor.
All right. Well, as your lawyer says, 3 years have passed, but that's your fault. This was bad. I suspect you were doing some road beering on the way either up there or the way back. I don't think you drank 16 beers and drove all the way to Grand Rapids and all the way back before this accident happened at Zerby Road. But it was bad. You went off the road into a field and you're out there and your brother-in-law's out there in the dark. And then you didn't show up. I'm not going to do a probation. It is impaired, which in Michigan would allow you to keep a restricted license. We did get a bond posted, but I think it was a surety bond. Once upon a time, I had a file. I could open it up and I could see a bond receipt in it. Now I have to do a scavenger hunt. I think I set the bond at 500 cash or surety on a bench warrant. And then when you came in, I canceled the bench warrant, so we don't have any bond money. There's a $300 fine, drinking, driving, expensive proposition. $125 of state minimum costs. $75 crime victims' rights fee and a $50 state minimum fee. There is a $255 reimbursement to the sheriff's department. There's a $150 attorney fee and a $100 screening fee. That all adds up to quite a bit. 300 plus 125 plus 100 plus 150 attorney fee plus 255 police reimbursement equals $930. I make that due in 6 months. Due by 12/3. With a payment plan. One day that you spent that night and an extra day for blowing off your arraignment. The guideline range was 5 to 7 days. But the reason this is 3 years old is because you just didn't show up. And then when there was a consequence, you did. 2 days jail credit, 1 day to serve. And I don't want to screw up your employment. We're going to schedule that at a time that works for you by the probation department. I don't know what this will do to your Indiana CDL. I don't make any prediction about what that's going to do to it. But if it was a Michigan, you would be allowed to drive to and from it in the course of employment. So I want you to go out with Mr. Huff, and I want you to go to the probation department. They're going to schedule when you're going to do this jail time, unless you want to just do it. Did you want to just do it this weekend? Or is it life too complicated?
I have a forensic interview tomorrow.
All right, I'll leave you and Mr. Huff to work out a date.
Make sure you do it with that.
Thank you.
Your Honor, thank you.
All right, good luck, sir. Ashley Armour. Good morning, Ms. Armour. This is file number 26437, People versus Ashley May Armour. Ms. Armour's here with her lawyer, again, Casey Strong. She was charged with operating while intoxicated on March 6th. Pled guilty at a pretrial to impaired driving. The matter was set for sentencing this morning. Daniel Frazine is here from the probation department and he prepared the screening report. What would you like me to know, Ms. Strong?
Thank you, Your Honor. I do not have much to add from what was in the report. This was a plea to an impaired driving. Ms. Amore has limited criminal history and has not had anything alcohol related in the past. She is employed and she is working to maintain that employment. And I would ask the court to consider putting her on the term of probation as recommended by the probation officer. She did try to do the victim impact panel, which is part of the recommendation. There were a lot of classes available and she wanted to make sure she selected the right one. So she's going to do that as a term of her probation, but she did try to complete that ahead of her sentencing here today. I would ask the court to follow the recommendation and impose that term of probation.
Thank you. Daniel, anything you wish to add?
Just quickly touch on this. I know a lot of times we're on the borderline of the presumption here. She had a fairly decent BAC, but because of her past history, which she voluntarily admitted to, she has no criminal history of meth use, but because of her past substance use and the fact that she was sitting here by herself drinking and then drove with her lights off, which was, could have very easily killed herself or someone else. I do believe it overcomes that. And with speaking with her, she also agrees that it would be good to have some supervision and some help along with her struggles so she can overcome this. I think she was very sincere about this. And I think that she is still struggling. So for the best chances of a good reformation and better future prospects for her and her family, I do think the probation is merited, Your Honor.
Ms. Armour, what would you like me to know?
I'm very sorry and that'll never happen again. I'm embarrassed.
That's a good response. And we get hundreds of drunk drivers a year times 47 years. That's a lot of drunk drivers. And many of them are like that. I don't want to do this again. This was embarrassing. It was expensive. I know a guy that I went to school with. He got a drunk driving. He said, it was so embarrassing. He hasn't had a drink in 19 years. He said, I quit drinking. And I don't know whether that's in your future, but you hadn't done this kind of thing before. Now, you lost your mother and you lost your father. And as you know, I knew your father. And there's a grieving process, but this ain't good. Leave your son behind if you had collided with somebody while you're driving with your lights off. And I think there's more of an issue there than meets the eye. You're drinking in the dark with Captain and Coke and it's killing the pain. So I tend to agree with Daniel and you that you think a probation is appropriate. I'm going to put you on a 12-month probation, which means you can be done at the end of 6 months. As Daniel mentioned, there's a presumption that there isn't any jail time, but I'm going to order 3 days jail, credit 1, and defer 2. You're not going to do any more jail if you do what I ask you to do, okay? This is expensive. It's $300 fine, $75 crime victims' rights fee, $50 state minimum fee, screening fee of $100, $150 attorney fee. Let me get them. It's still the last case. Mr. Young. Apparently there was no police reimbursement requested, and we don't have the prosecutor here to help us. So I'm not going to order it. I am going to order the victim impact panel, which is $32. So let's add that up. 300 Oh, wait a minute, probation oversight fee of $480. Now you can do this in as little as 6 months. It saves you $40 a month. 300 plus 125 plus 100 plus 150 plus 480 plus 32. It's a lot of money, 1,187. I'm going to order that you do substance abuse counseling and treatment as directed and sign a release. They include the Crime for Life class. I'm ordering you to do victim impact panel. He abstained from alcohol and be prepared to take a test upon demand of any police or probation officer. Do you use marijuana? You had in the past.
No.
I think a high percentage of our drunk driving cases that we get, people are also using recreational marijuana. We don't have any statistics on how much marijuana is in the defendant's system at the time of the arrest. And I know you'd struggle with some harder stuff in the past. I'm very glad you said all that. I can tell by just looking at you, you're not doing meth.
No.
But this isn't the answer to your question. But I think this was a wake-up call for you, as somebody said earlier. You're not going to do any more jail if you do what I ask you to do. And I think you're doing good. All right, you go with Daniel. Yeah. And we'll get you plugged into that probation.
Would you like to take care of Ms. Smith, or would you like to see Ms.
What's that?
Would you like to take care of Ms. Smith, or would you like me to step away?
We'll do Mr. Smith. Poor Mr. Gibson always ends up getting last, but
Ms. Smith?
you Smith, she was late, but we'll address her. Good morning.
Good morning.
Do you really want your son to watch this?
No, not really. That's why his dad's here. If they can step out, it'll be fine.
All right. I like the sunglasses though. You look pretty cool.
Everybody.
I was about to be sentenced on a use of methamphetamine charge. I wouldn't want my kids to
Yeah, I
sit
wouldn't
here and
want
watch.
them to hear either.
What?
I didn't want him to hear either. I didn't realize that. I forgot that I didn't realize court was at 10. I thought it was at 1. Otherwise, I wouldn't even have him today.
Well, that's a problem. I told you in the courtroom it was at 10. We sent you a written notice that it was at 10. Your lawyer sent you a notice that it was at 10.
And Your Honor, to Ms. Smith's defense, I did send her a message this morning and she replied immediately and got in the car.
Yeah, well, I'm glad you're here.
Thank you.
But you ain't tracking real straight, and you wouldn't have brought your son to a felony
I know.
reduced to a
It
misdemeanor
wasn't meant to be
sentence.
like that.
I'd be
Apologize.
embarrassed to do this in front of your son. All right, this is screwy. And Ms. Strong and I were discussing this. The file number here is 26603FY. Charged possession of methamphetamine, pled to use of methamphetamine. The affidavit is all about a larceny.
Yeah.
A bunch of stuff got stolen, expensive stuff. And it all has to do with another guy. And as far as I can tell, they've never charged him with anything. You're there, this house or this trailer is full of stolen merchandise. The police, I'm like, where is this? And then later on at the bottom, there you are with some 0.7 of a gram of meth that you admitted, and I think a pipe. So I'm not sure what happened to this guy who owned the property, Zachary Gardenier, but I couldn't find that he'd ever been charged with anything. At least not related to this. So you're at the wrong place at the wrong time and you got some meth in your possession. And $8,000 to $15,000 worth of stolen stuff in there. And so I don't know what, I think you know something about all that, but this isn't about that, and the prosecutor isn't here. Is this the one that we did a test that day?
Yes, Your Honor. She did a test at the time of her plea. That test came back negative.
And this is another case that you're going to be asking for 7411 probation.
Yes, Your Honor.
All right,
She's
what would you like-
eligible and I would ask for that opportunity.
All right, what would you like me to know?
Well, Your Honor, as indicated by the court, there was a larger situation going on. Ms. Smith admitted to law enforcement at the time that the methamphetamine found was hers, and she admitted it at the time of the probable cause conference. While she's not making any statements as related to the merchandise or her knowledge of that situation, she very clearly stated that the methamphetamine was hers. She's not trying to minimize. She struggled with substance use and abuse in the past. As the court learned at the time of her plea, she did not have methamphetamine in her system at that time. She's indicated to me that if she were to test today, she would be clean, which is indicative of an opportunity to be on that 7411 probation. She understands that she struggled in the past with substance use and abuse and sees this probation as the opportunity that it is to overcome that addiction and move forward with her life and hopefully stay out of the wrong place at the wrong time and stay out of the criminal justice system at the conclusion of probation. And she will not have a drug charge on her record if she benefits from the full 7411 program.
All right, Ms. Smith, what would you like me to know?
That I am taking accountability for my actions and I have been doing great and I'm ready to get this on with my life and to stay good in my own.
So when you say doing great, what are you doing now?
I'm a stay-at-home mom. I don't do anything that I shouldn't do, no drugs or anything like that. I drink
Right now,
occasionally.
your child's, is that your husband?
It's my boyfriend and his son, my
But
stepson.
is that?
We have 8 kids altogether.
But is he the child's father?
Yes.
Okay, so he's here supporting you and your son.
And I believe that he arrived after they did, given the circumstances, because she was with the child. They appeared at court and she asked someone to come from work to be with the child just in case, to be respectful to the court.
What were you doing at this place where all this stolen stuff was?
And I just want to make a blanket, this case has not been charged. And I would like to make sure that there's no indication of any
Well,
kind of
I'm gonna
involvement.
make a condition of probation that she cooperate with the prosecutor if she gets a subpoena.
If she gets a subpoena, yes.
It was a huge mistake. It was a huge mistake. It was purchased, this trailer was purchased from somebody that we associated with. a
Well,
friend
how
of
do you
ours.
know this Gardner guy?
It's my fiance.
Oh, that's him?
Yes, he works every single day. We purchased this trailer.
All right, stop.
Yeah, okay.
Yep, Your Honor.
We didn't do anything wrong. We didn't do anything.
I don't want to get into it, Your Honor. We're here for use of methamphetamine, 7411 probation.
Okay.
So you're okay.
All right, well, obviously, the prosecutor knows more about this than I do. And maybe there's a legitimate reason why it never got charged. But this was only a few months ago. But you don't have much of any criminal history that I could find. Even though you don't show up when you're supposed to, you're here now. I'm gonna do the similar to a case I had earlier this morning. I'm gonna do a 12-month probation under 7411. 31 days, credit 1 day. I think we got 1 day credit. I think you actually came into the court. I don't think, did you ever actually go to jail?
Did I ever go to jail?
Yeah.
No, I did not.
All right, I'm going to 30 days jail credit 0. And of the 30 days, I'm going to defer all 30. I'm hanging 30 days of jail over your head. You're to do substance abuse counseling and treatment as directed, and you're not to use any controlled substances, and you're to sign a release. You're to test as directed. No drugs and no alcohol. Are you doing any kind of treatment now, or you just stopped cold turkey?
I just stopped cold turkey.
Well, that's not hard. It's like holding your breath. We're going to need to do a little something of
Okay.
some sort of programming. All right, again, this is an expensive proposition. $75 fine, $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, $480 probation oversight fee. I guess that's it. I don't have any bond to apply here. That's $830 doing 1 year as part of the probation. 7411 is a section under the Public Health Code, 333.7411. If you complete this probation, the charge will be taken off your record and won't show as a record of conviction. They used to suspend your driver's license for this. They don't now. I was never really in favor of that. That's one of the things they changed in the Criminal Justice Reform Act. So it doesn't affect your driving privileges, but you don't want a methamphetamine conviction on your record. So you want to complete this probation. All right, again, I don't have a handy probation referral, but I'm going to send you out to the counter. And again, you'll have to wait. And I think one of the probation officers can start the intake process.
All right, thank you.
Thank you.
All right, you're good to go.
Have a great day.
All right, Mr. Gibson, let's take up your case. Thank you, Ms. Strong. Alicia Sanchez Wilson. This is file number 26383OD. You're Alicia Sanchez Wilson?
Yes.
All right, we've met several times before. This is the time for sentencing on a charge of operating while impaired. Patricia Walton is here and she's prepared the report.
Priscilla.
What?
You said Patricia.
Oh, Priscilla, I'm sorry, I know the difference. I'm lucky I didn't call you by your previous name. Priscilla Walton is here, not Patricia. And she and I discussed this case yesterday. I have some concerns about you. You are burning the candle at both ends and the middle. And I don't know what to do with you. Mr. Gibson, what would you like me to know?
Well, I think that the defendant was very honest when she spoke to the probation agent. She admitted to, drinking quantities of alcohol, I guess you could say, that are concerning. And I think a lot of people, when they're in the same position, will minimize what they drank, and they don't necessarily admit to the full drinking. But I think she was very honest. She's lost because of implied consent. She will now have a 1-year suspension. So she doesn't have a driver's license. She has a 3-year-old son that she cares for. And so I think that here, if the court is inclined to give a term of probation as recommended, I believe that the defendant could complete a probation term, and I think she could do what's asked of her. I don't know if the court, it's recommended for 24 months probation. I don't know if this would be more appropriate with 12 months probation. So I think that Ms. Sanchez Wilson understands that going forward, drinking and driving is never appropriate, and she obviously made a bad decision on this day. Thank you.
All right. I'll hear from you next, and then Priscilla Walton. Usually I do it the other way around, but I may have some things I want to say. Ms. Wilson, or Sanchez Wilson, what do you want me to know?
I understand that my alcohol problem has become a big problem recently. I have been wanting to get sober. It's just hard for me, but with the probation, I feel like it's the wake-up call that I needed to get sober. And I've been saying that I wanted it, and I feel like this is finally like the point where it's going to happen if I get this probation, and it's something that needed to be happened. But yeah.
Have you done anything? Have you gone to an AA meeting or anything?
I've talked about it. I've just never really looked into it and done like the actual research to do it. Really, I just try to go cold turkey, but it just,
that's not,
yeah.
You're only 21.
Yeah.
But I'm very concerned. We have that disturbing the peace where you and some other kids went in the store and stole a bunch of liquor.
Yeah.
And you were not even 21 yet. You had that accident where you went off the road, and I suspect alcohol was involved, but you in May of 24, Hoffman and Wood Street, they found your car crashed and abandoned.
Yeah.
They found all your stuff in it. And then you left the scene. You didn't have a valid license. You didn't have any insurance. You don't have a valid license now. You also had the assault and battery in 24 against Matthew Simon, which I think alcohol is involved. This one, you don't have a valid driver's license. You're not supposed to be driving anyway. You go to Sturgis and you drink large amounts of alcohol, Long Island iced teas, twisted teas, other stuff. And then you're just going to get in the car and drive back to Three Rivers. That just frightened me.
Well, it was my vehicle, but I had a DD from the bar to Three Rivers. I guess I should have stayed the night at the DD's house, but I ended up going home, and that's why they had caught me in Three Rivers heading out to where I lived.
Where were you living at that time?
I was living with my mother on Arthur L. Jones Road. That's where I currently live as well.
Yeah, that scares me.
Yeah.
I mean, your judgment is so bad. You have no license. So you drive over there with no license. You almost croaked yourself on that other incident where you crashed your car and left. So you go from Three Rivers to Sturgis, drink a bunch of alcohol, and then your plan is to drive home with no valid driver's license.
Yeah.
While someone else is watching your son. So they pull you over. She denied using any alcohol. She did a PBT. Oh, she denied a PBT, so a blood draw was taken.
Yeah.
So you denied you were drinking, you denied the test, they did a search warrant. They suspended your license because you didn't take the test, but you don't have a license anyway. Did you ever have a license?
No, I just have my permits.
So this is just full of bad, immature thinking. When's the last time you worked someplace?
I was working when we came to this court.
Well, you worked at the Meyer Distribution Center,
Yeah.
but you're not working now?
No, my boyfriend had ended up getting a third shift job, which I worked third shift too, and so he ended up taking the vehicle so he can get back and
All
forth from
right,
work.
do you live with him?
Yeah, we live at my mother's house, yeah.
All right, so is he the father of your child?
Yes.
Where was he when all this was going down? At work?
I can't remember if he was at work or if he was with our son at the time.
Well, I bet he was thrilled.
Yeah.
Anyway, some of it is that you're immature. You're young, but Priscilla and I discussed this case yesterday, and I'd met you in these earlier cases, and I said, I don't know what to do with her. Maybe I ought to just give her 90 days in jail and hope it changes her conduct. But you are only 21, your brain's not even done developing yet, but these are real bad decisions. Priscilla, you've met with her, and I think she was pretty open and straightforward with you. What would you like me to know?
I think, Your Honor, Ms. Sanchez Wilson does have a real problem with alcohol. I think she's, young enough that we can, placing her on a probation term, we can address these issues with alcohol consumption and see what's going on here. Like Mr. Gibson said, he'd like to see a 12-month probation, but with a 24-month probation, if she does well, she could be eligible to complete it in 1 year. I believe because of the aggravating factors in this case, we can depart from presumption of fines and costs. I think a 24-month probation eligible to complete it in 1 year will give her enough time to be engaged with treatment, Your Honor.
Whose idea was it to go to the bar on US 12?
It was just a group of friends.
All right, where are these friends from?
At the Rivers.
And they all decided to go to this bar over in Sturgis?
I think it was an event that was happening there that night.
Like a birthday party or something, or what?
No, like the bar hosted an event. And we just all decided to go.
Now, who was the designated driver that was with you? Just give me a first name.
Her name was Louise.
And where does she live?
Three Rivers.
Why didn't she drive home?
She drove to her home with my car, but then I just decided to go home.
Where does she live?
Riverside.
All right. Okay, that adds some sense to it. You're right, you should have stayed at Riverside.
Yeah, I just decided to go back home.
All right, well, I'm glad that you weren't driving down US 12 and Lutz Road or wherever you guys went to get there. I don't know what kind of shape your friend was in. Also, one thing that Priscilla and I did agree on, you need a probation. You need a large kick in the rear end. You're not working. Other people are helping take care of your child.
Yeah.
You don't have a driver's license. All right, I'm going to do a 24-month probation. The impaired doesn't matter because you lost your license for not taking the test. I tell everybody, take the test. Why wouldn't you take the test?
I did, I just failed because I couldn't parallel park.
No. We talked about that before. I told you to get one of those automatic parallel park cars, but
yeah.
Why didn't you take the blood test from the police?
I don't know. I was just drunk, just didn't want to take it.
All right, which is part of your whole
Yeah.
attitude. All right, I'm gonna order 24-month probation. I'm gonna order 36 days in jail, credit 1. Of the 36 days ordered, I'm gonna defer 32. Means you got 4 days to do, 2 weekends in jail. I want to get your attention. I want you to get your GED or diploma. It says in here to get a valid driver's license, but right now you can't get a valid driver's license because you're suspended for failing to take the test. So I'm not going to order that. We really need to get some substance abuse treatment. You are at least wise enough to know you're only 21, but you got a terrible alcohol problem.
Yeah.
And your child deserves better than this and watching you go over the cliff. I'm going to waive the fine. You don't have a lot of money, but I'm going to order the $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, your attorney fee, $960 probation oversight fee, $200 police reimbursement to 3 Rivers PD, $32 for the victim impact panel. And I want you to get a job.
Yeah.
Obtain employment. The reason I put 30 days in here is I'm afraid that this isn't going to work. My hope is that it will. You had an easy opportunity to seek some substance abuse treatment, but you didn't. And let me say this, it's really hard to get a 21-year-old to understand that they have an alcohol problem. Because it's fun, for one thing. You're out drinking with your friends and everybody's having a good time, and you think, well, that isn't me. Sometimes when they're about 50 and they got hit on the head 22 times, they realize that it hurts and they're ready to stop drinking. I've had very poor success. I'm not sure if it's oxymoron. Anyway, not much success with trying to get a 21-year-old to not drink. So we're going to do what's called a timeout. We're going to test you periodically to make sure that you aren't drinking. We're going to try to recommend that you go to some treatment. But your whole rest of your life is going to be a big mess if you stay on this path.
Yeah.
And the other part of it is just coupled with bad judgment. But to your credit, and you were honest about it, when you're drunk, you don't have very good judgment.
Yeah.
Your friend gets to her house and you're thinking, I can drive. And you're a 1-4. And then the police ask you to take the test. And you're like, no. Again, you're drunk and you don't have good judgment.
Yeah.
I want you to get better judgment. I would also like to stick around long enough to have you get a driver's license. But if I'm not going to order it because I don't want to keep you on probation for that. But I do want you to get a GED or a diploma. You have to do one or the other. You don't have to work and get a GED. I prefer you did. But I want you to get a diploma or a GED. Otherwise, you're going to go the rest of your life without that. And if we can get over that hump, I call it dragging people over the finish line.
Okay.
And you got 2 weekends in jail to do. That won't be fun, and that's to make sure that you don't do this anymore. Those other ones all scared me. the assault, the crash where you left your car, stealing the booze from the store. All those are things that show there's a burgeoning alcohol problem. I'd like to change it. What I'd like to hear is that you do a good job on this, that you go on your probation, you take this seriously, you don't drink any alcohol, spend time with your family, spend time with your son, get a GED, and I leave you in a better place coming out than you did coming in. Sometimes that happens. People stop me on the street. Lady ran out and stopped me at the gas station. And she said, I just wanted you to know I'm 14 months clean. I'm about to graduate from drug treatment court. I'm doing really good. I like hearing stories like that. A guy stopped me in the parking lot out here. He said, I've been sober 6 years, got married, got my driver's license back. There are some success stories out here. I'm at the movies. Somebody comes up and says, hey, thanks for what you did. I've been sober now for 2 years. So I'd like to hear that kind of story from you. Anyway, I want you to go with Miss Walton. And she'll get you started on this.
Thank you. Thanks, Your Honor.
Thank you, Patricia. Thank you, Priscilla. Thank you, Mr. Gibson.
Yes,
I
thank
told
you.
Casey this was going to be a no lunch Wednesday, but it looks like we're done.
We made it.
Sorry, Your Honor.
Approaching the bench, Ms. Webb, can
It's running. Did she just
you please state your name for the record?
your breath? She just kind of came up and said, never mind.
I'm trying to be efficient, Judge, all right?
Okay. Your name, ma'am?
Nakaya Parker Webb.
And what are we doing on?
Your Honor, I was recently appointed to this matter. I did receive some discovery yesterday, just requesting another pretrial date to allow me to review the discovery and have meaningful conversations with my client.
17th or the 1st?
Your Honor, let's see, the first.
P number is 8. She ain't got nothing. Sorry. I shouldn't have said that. First.
The first will work, Your Honor.
Right. I'll adjourn this then to July 1st, 2026, 9 a.m. or as your invite indicates.
Thank you, Your Honor.
Thank you, and bond will continue. Thank you, ma'am.
Thank you. Have a great day.
Court calls the case People versus Brenda Miles Roberts.
Conrad Solar on behalf of the school township.
Yeah.
Good afternoon, Your Honor. Robin McCoy, P63057, on behalf of Miss Brenda Miles Roberts, who stands to my right. She'll stand mute and waive the reading of the information.
Well, ma'am, state your name.
Brenda Miles Roberts.
This is a type for arraignment. Defendant having waived from a reading standing mute, court will enter a not guilty plea. Initially in the case, I do have before me a plea form. Is that what we're doing today?
Yes.
Yes, sir.
Plea form indicates that the defendant would be pleading to an added count 2 of operating while visibly impaired, the 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Brenda Miles Roberts.
Damn it, it's the court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the costs of the prosecution as well as the costs of any emergency governmental services. You understand all of that?
I do.
Still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Did you understand that by pleading guilty, you'll not have a trial of any kind? Yes?
Yes,
Signed an advice of rights form, is that correct?
I did.
Any questions regarding any of those rights?
No,
Please look at paragraph 5 on that copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal over it.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plead?
no,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily and of your own free will?
Fine.
And also because you believe that you are indeed guilty of this offense?
Yes,
April 19, 2026, at the location of Packard Road, Pittsfield Township, Washington County. She's operating a motor vehicle.
yes, I was.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes,
What'd you have and how much?
wine.
Wine?
Mhm.
All right. Were you stopped by the police or was there an accident?
It was an accident.
What happened?
The light turned yellow and I went through it.
Okay. And then what happened?
It was an accident. A car came out of nowhere, came from the other side.
Okay.
So by the time it was too late for me to stop.
Okay. And so you hit another vehicle? All right. Did the police arrive?
Yes. Huh?
The police arrive?
Yes.
Were you taken to the hospital?
Yes.
All right. Was there a blood draw?
Yes.
What were the results of the blood draw?
173, Your Honor.
That's correct, Your Honor.
0.173. Pam, do you have any reason to dispute those blood test results?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Ma'am, I do have to advise you that if I accept your plea, and between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation.
Yes, I do, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred from Schwartz for an assessment and victims impact panel. Sentencing in this matter will be July 8th, 2026.
Let's see. You said 9 a.m.?
Yes.
Okay.
Or
Actually,
as your,
for something else.
pardon?
I have something else too with on the 8th. Okay.
Her bond in this case will be set the amount of a $20,000 personal recognizance bond. Although there are standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. You understand that, ma'am?
Yes, I do, sir.
There is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, sir.
I will also order that you report over to the Department of Community Corrections for placement on a sober link testing device. Okay.
All right. And Your Honor, I also advise her to look at AA classes, and the car in the situation was totaled. So she doesn't have a car as of now. So.
All right.
Okay.
All right. Thank you.
Yeah. Thank you.
Court calls case People versus Levi Gardner.
All right, so on behalf of Pittsfield Township. Ron Perry on behalf of Mr. Gardner, Your Honor.
Gardner? Not here.
No, he's right there.
Where again?
Access point.
Okay. Mr. Gardner, can you get yourself unmuted?
Oh,
Got it. Got it. State your name.
Levi Gardner.
Thank you. What are we doing?
I request an adjournment to get some paperwork.
I'll adjourn this matter to July 1st, 2026, 9 a.m.
Thank you.
All right. Thank you, Mr. Gardner.
Okay, thank you.
Court calls case of the people versus Quadric Gilliam.
Aaron Solar on behalf of the township.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Gilliam, who should be appearing via Zoom.
Yes. Gilliam, can you state your name, please, sir?
Quadric Gilliam.
All right. I have before me a plea form.
That's correct, Your Honor.
Indicates the defendant will be pleading to an ad account to allowing an unauthorized person to operate a motor vehicle. The 90-day offense. Upon a successful plea of that charge, count one would be dismissed. That's the court's full understanding.
Right. Yes, Your Honor.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
State your name again, please.
Quadric Gilliam.
Sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an eligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days incarceration and $100 fine plus court costs. You understand that?
Yes, sir.
All right. And understanding all of that, still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up those rights, including the rights under paragraph 5 of your trial rights?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay, were you on probation or parole at the time of this offense?
Yes.
You understand that this could be considered a violation of your probation?
Yes.
You understand that as such, that other court could sentence you to the maximum allowable under that other charge?
Yes.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
Are you also doing it because you believe that you're guilty of this offense, sir?
Yes.
On July 17, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yeah.
Did you allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to tell the court before I impose sentence?
No, Your Honor.
Fines and costs of $250. Suspend 90 days in jail. When can you get that paid, sir?
Can I get about a month and a half?
Okay. Can you get it paid by the end of July? Give you a little bit more time than that.
Yes, sir.
Okay, because I don't know what that month and a half is. I don't know what's going on. Anyway, just give you the whole month. Pay it by July 31st.
Thank you, Your Honor.
You're welcome, sir. You take care.
Thank you, you too.
Court calls case, People versus Joshua Hamlet.
Aaron Solar on behalf of the township.
Ron Brown appearing on behalf of Mr. Hamlet.
Good morning, Your Honor. Good morning, sir. It's afternoon, but whatever. What's your name?
Joshua Hamlet.
Thank you. All right, what are we doing?
Your Honor, I'm requesting an adjournment.
Okay, yeah,
Try to talk to him, and I called him a couple of times.
Adjourned to July 1st, 2026, 9 a.m.
Thank you.
All right. Thank you, sir.
Thank you. Take care.
Court calls case People versus Larry Hawkins III.
And Assistant Public Defender Nicholas Bukovich, I'm having Mr. Hawkins.
Larry Hawkins.
No objection from the defense.
You are so lucky today. Case is dismissed.
Don't worry, Mr. Hawkins will be there.
Okay, yeah. Court calls the case People versus Alicia Holston.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Holston, who should be appearing via Zoom.
Hi, I'm Alicia
Ma'am.
Holston.
Okay, you got it. Thank you.
Hi.
All right, what are we doing?
I'll be asking for adjournment, Your Honor. My client unfortunately recently had some instabilities in her housing situation. She believes she wants to accept the prosecutor's offer here, but she wants to make sure she'll be successful on probation in the future as it is a higher offer. She just needs a little bit more time to figure some things out.
July 1st, 2026, 9 a.m. All right, young lady.
Thank you, Your Honor.
You're welcome.
Thank you so much, Your Honor.
Court calls cases People versus Justin Mosier.
Township. Brown appearing on behalf of Mr. Middleton. Your Honor.
Yes, sir.
He's over at the jailhouse.
What?
He's at the jail. So we're going to request.
Our jail?
Yes, sir. So I was going to request adjournment anyway.
How do you know he's there?
Because I went to see him. Got a PC tomorrow with you too. So I was just going to request adjournment on this case.
Adjourn it to June 17th, 2026, 9 a.m.
Thank you.
Court calls case People versus Richardson.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Sims. I have no excuse for my client's lack of appearance today, Your Honor. I did attempt to contact him, so I'll be requesting an adjournment.
And warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000, like with 10% privilege. That warrant will issue. Court calls case People versus Eric James. Yeah.
Ron Brown appearing on behalf of Mr. Smith, Your Honor. Can you introduce yourself?
Eric Smith.
Your Honor, requesting adjournment. We're trying to get some paperwork over to Mr. Silla.
Adjourn matter to July 1st, 2026, 9 a.m. Bond continues.
Thank you.
Thank you.
You're welcome. Court calls case People versus Jeffrey Thompson.
Township. Ron Brown appearing on behalf of Mr. Thompson. Can you unmute?
Sorry, can you hear me now?
Yep, we can hear you.
Oh,
How
hi,
are you,
Judge Simpson.
Thompson?
I'm okay. I started a new medication last week for bipolar, so it's been really helpful. Waiting to see like what we're going to do with liver enzymes and whatnot, because it may counteract like some of the other things I'm on for something else that you knew was going on. So, but yeah, I'm pretty good. It's the only thing was I haven't had an opportunity to touch base with the attorney there. There was a delay in getting the assessment done for the driver's license. So we're waiting on that right now. That's the only thing that I haven't had a chance to talk with the lawyer about.
You okay, but you haven't had a chance to talk with your attorneys.
No, not yet. He called, but I was at my mom's place when he called, and I believe it may have been yesterday. I don't remember. I've got the voicemail though. But
right.
I showed up early today because I thought I was supposed to be there at 9. And Ann was texting back on Zoom. I was like, oh man, I always screw it up. And I screwed it up last week because I was supposed to be in the Ann Arbor. I guess I was supposed to be in the Ann Arbor court. I showed up at your court and I was like, oh boy. So
All right.
I guess
that's
the lady's
okay.
trying to help me trying to get that rescheduled, but I felt really bad afterwards. So Joy and Casey and a couple other people were aware of it. It's just like, I'm so used to coming to see you in that courtroom. And it's like, even now, like even on Zoom, I still get nervous. I'm like sitting here, like gnawing away at my fingers. So I'm sorry.
Okay. No, it's all right. Just stop it. All right. Look, you're good. You need an adjournment then on this?
Please.
All right. I'll adjourn it out of bounds to July 1st, 2026, 9 a.m. All right, Mr. Thompson?
Okay. Thank you, Judge Simpson. I appreciate it.
You're looking well.
Yeah, I feel a lot better. It's still like we still need to get, the scary part is like just getting like with the psych meds is getting the liver enzymes in check. So
yeah.
And right now with the other thing going on too, which medically I think you're aware of, it's
yeah.
I feel a lot better from where I was several weeks ago. So
yes, there you go. But you're looking good.
Thank
all right.
you.
Keep
okay,
that
thanks
up.
to Ann too and the attorney there. I really appreciate it.
All right, not a problem, sir. We'll see you in July.
Okay, thank you. Bye.
Bye. Take care.
Court calls the case People versus Travion Weaver. Hello.
How you doing?
Good. Your name?
Travion Weaver.
Okay. Mr. Weaver, you are.
Your Honor, maybe I can speed it up.
Okay.
I'm going to move this case.
No.
Yes.
No, Mr. Weaver wants to plead something else. What? What? He did?
It's a good day.
He did this all.
Brown Elton. Mr. Brown Elton.
No, don't even try that. Go.
Yep.
He's like,
it's one of the.
He came in with all of his documents and stuff. So you, sir?
I was prepared.
Yes, sir.
My mom always told me come prepared, so I can.
All right. So you have no objection to it being dismissed?
No, not at all.
And I'll tell you what, it gives me great pleasure just to say case dismissed. You take care of yourself.
You too.
All right.
Not to interject, he wants to get his bond money back.
Oh yeah, I forgot I had to put a bond.
Oh no, we don't give money back.
We don't do that.
We don't do all that here. We don't get a dismissal and that. No, what? Oh, you did post. How much did you post? 260.
I remember. I think I did it to 14A2.
No, I don't. I see $2,500 cash surety, 10% bound SAT, but I don't see. When did you pay it? Can I see what he said?
That's a receipt.
Oh, okay. You got the receipt. So you paid 250 and you paid it over on Michigan Avenue.
Mm-hmm.
Let's see. When did you do that? May 1st. So it should be here. You know that, man. It should be here by now. Of course, I'm not going to have a problem with you getting your money back. So you'll need to stop out at the front counter.
Okay.
And just show them the receipt and tell them that you'd like I'm going to put it in the file so there won't be an issue.
Right. So they'll go down there. He didn't tell us that.
Okay. So I'm going to put your return bond. And so they should be able to help you out with that.
Okay.
Posted it over there. It should be over here. We can help. Otherwise, you may have to go over there to get
next to Michigan. Okay.
Yeah. But
all right.
All right.
Thank you. Appreciate it.
Not a problem. Appreciate you taking care of business. That's it for the whole day? Wow. I'm efficient. Everybody's waiting on me. All right. 14A stands adjourned. Thank you.
All rise.
I know. Yes.
I